Okay. Hello students. Property law and easement. Our topic for today is acquisition and imposition. Imposition is a right which is created voluntarily. In this, the owner of the land who has a transferable interest, that owner of the land can impose on his right an easement. He can impose on his own right an easement, and that right can be only to the extent of his own right. The easement right that he is creating can only be to the extent of his own right. For example, an illustration is given that A, who is the tenant of B's land, under a lease of 20 years, which is an unexpired, under the lease of unexpired of 20 years, and over here, A, who is the tenant, he has the power to transfer his interest under the lease. So, A can impose an easement right on the land till the during the time of his lease agreement, during the time his lease exists, or for a shorter period. Modes of acquisition. Modes of acquisition is express grant or implied circumstances. So when you talk about express grant, it is expressed on the agreement or the deed or the mortgage or whatever form of transfer is taking place. So there is a clause that is inserted, and it is clearly mentioned in that clause that this kind of easement right is being given, and in this case the grantor is giving a clear intention of expressing his grant for right of easement. If the value of the immovable property is rupees 100 or above, then it is compulsory to it be in writing and duly registered. Then in implied circumstances, implied is when if there is A, then it is if A exists, then B will also exist. That is implied, that you know that to make A exist, B is also necessary. So the first point of implied circumstances, easement of necessity, where there is a such kind of circumstance that the occupier or the owner of the land cannot enjoy or exercise his own property without the right of easement over the servant heritage. Thus, absolute necessity occurs, and it is a test. It is a test and the convenience. For example, X sells his land to Y for agricultural purpose. Here, Y cannot access his land without passing through Z's land, his neighbor. Thus, this is a easement of necessity. So, over here, so that he can enjoy the land Y, he can do his agriculture over there, he has to pass Z's land, who is his neighbor. So, he needs the right to way, and thus, to make sure that he's enjoying his own land, he has to pass Z's land. So here it is the easement of necessity. When a joint property is partitioned among various co-partners, and if right of easement over one share of the property is essential for the enjoyment of the share of the other co-partners, then later shall be entitled to easement. Quasi easements. In the case of a person transferring his property to another person, then if an easement is continuous, apparent, and necessary to enjoy, then in such a case the transferee shall be entitled to it. So if these three conditions exist, then the transferee will be entitled to this. If such an easement is continuous, apparent, and necessary to enjoy the said property, the transferor has a right to such easement over property transferred by him. So the transfer has the right to such easement as well. In case of partition of the property of a joint family, if an easement is continuous, apparent, and necessary to enjoy the share of one co-partner over the other co-partner, then he is entitled to such a right of easement. So, in partition of the property, also the right of easement exists. Easements are quasi, as those are arising out of circumstances. That is when common properties are converted into tenements by way of sale, mortgage, partition, or through any other form of transfer. In such a case, there is an implied grant of right of easement. For example, P's right attached to Q's house to receive air and light through a window without any obstruction by his neighbor. This is continuous right. This will always exist. It is continuous. Prescribed easements. Section 15 provides for this type. Following are the requisites. First, right must be definite and certain. Second, right must have independently enjoyed without any agreement with the servant owner. Third, it must be enjoyed openly, peacefully, and without any interruption for a continuous period of 20 years, and in respect of any government land for a period of non interruption should be of 30 years. So this is a prescriptive easement. Now customary easement. Customary easement is under section 18. It is an easement right which can be acquired by virtue of local custom. For example, people living in a particular city or town having a right to bury the dead in a particular area. This is or riparian right to use water. Thank you.